Hello again. This is Ben Hitchcock Cross talking to you today. And Milwaukee Public Schools did not have a good week. This would have been the second week there in February of 2025. SRO decisions, other things coming down too. And they lost, as I understand it, Angela Ford versus the Milwaukee Board of School Directors. There's gonna be a whole bunch of stuff with this. We might stop. We're just gonna be straight up Ben here. Um, I've not read this decision except for the headline that I got texted to me last night. You're seeing me in my as I am outfit, and we'll see how things go. Let's let us do it. I guess just a preamble here. What we're talking about is Angela Ford versus Milwaukee Board of School Directors, 13 days. I mean, it's a trend of them, not the first, and certainly, hopefully, it's going to be the start of the last hearing that we're all set to go to hearing, and the hearing commissioner cancels it on some discovery because of some alleged discovery issue. So that's really what's being set up here. This is, to be clear, and boy, have I buried the headline. This is the hot mic judge, Benita Larissa Morgan, who, recorded her wish that I would be arrested, that she had accept cases to like prove that she was tougher than me, um, and on like that. Please check out that recording there. The best one can say about that recording, I think, is that she reveals herself not to be a third party neutral, um, which is what her whole job is designed to be. And here I think that's also what's going to be indicated is because she's so angry. And I want to frame this time where, because this case here is the beginning of, um, and it's sort of a but for thing here, but if it wasn't for this case, I don't think we'd really be at where we were at with the Equal Rights Division, meaning we would not have pushed things this far, um, for so many things. Now, um, very possibly there's other issues that would have been at play, and but for those, we still might be where we are, maybe just longer, but I want to put this in context here. So, um, we had a case that we won against Woodman's that we put up recently at LIRC because there's this recording, and we have to we won that one, and that one was with Judge, as you call him, Judge Word Salad, and that case we seem to lose for like really no explicable reason there, especially given the fact that there was a recording of what was going on, and which was really troubling. The next case that we had with there was the one where um, Novak, where we find out that Amy Petracek is part of the whole thing, but we don't depose her or we don't ask her questions for a bunch of different reasons, but also because we found out at the hearing what her involvement, and it come to find out that everybody else in the room except for us knew that Amy Petracek was at that time the judge's boss. Um, and only after that, so we learned that after the fact, and the judge ruled that a that wasn't a proper, it wasn't her fault because I should have objected at the hearing when she was the only one. Again, the facts are that she knew about it, which she admits in her decision, but we didn't know about it. So it's troubling there. Again, it's my assertion that if the judge's boss, and we've established now that it's not a independent discretionary relationship as if between a chief judge and a judge, that the relationship between a ALJ and a secretary of the Department of Workforce Development is master to servant. It is employer to employee, and that issue is, I think, controlling over all that, meaning that she had the duty to divulge that. So I would say at this time we're raising this issue about the Alice Delau decision. Alice Delau puts her decision out. We object to it. She retires, and then we go for we get this happens here. Is that's my recollection of like a few months later. And the setup on this is going to be there is a dispute about discovery. Um, Fine. And so in response, she orders us to respond to discovery. So which we say that we do, and we fax it to them at like 4:37. And they then come back and say, this is Milwaukee Public Schools comes back and says, well, it's 4:37 is too late. Which we've established that that's not the actual deadline there. So, well, I don't know. There's a whole host of issues. I assume they're not going to bring up the hot and Mike Judge stuff, but who knows? Um, I can't imagine that. I mean, this thing has been sitting there for almost 2 years, and we'll see the timeline here. But um, they have this is LURC. Do we assume that these things are not connected? But one wonders, let's put it like that, if the fact that the hot mic judge is before the circuit court is leading to this. I don't know. I mean, they may have just take their time. I don't have enough data really to put that one way or the other, but it feels odd that this is happening, or also that it was on this week here when there's so much MPS news. Um, but I don't know. Let's just say I'm going to put it another way. It's definitely the case that when it rains, it pours, and that's just how things go. So, but it's also the case that the human mind wants to connect everything together. So, we'll take it as it comes. All right. Boom. Angela G. Ford, Labor and Industry Review Commission, Milwaukee Board of School Directors. Remember, ALJ, an administrative hearing, is not normally that would go to the directly to the secretary if it was the Department of Transportation, or you want to get your probation is being revoked, you go to appeal that to the Lichner or whoever the current secretary is. Mr. Hoy, I got it. And you do that, and then you go to the circuit court after that, appeals court, Supreme Court, if that's if you're invited. That is the flow. Here, there, because I assume because there was problems with the secretary, there is this labor and industry review commission that that I guess acts as an appeal body. That's the fair thing to say. Now, they have made this argument that because it's the labor and industry one is really the ones that make the decisions here. I think we need to go back on that LIRC on Novak if any LIRC people are watching, because we now have definitive, straight up proof that that Pamela McGilvery is interfering in active cases with this judge right here, Larissa Benitez Morgan, that she's interfering in these cases during the hearing. So that's, they have said to us time and time again that really sort of the bias way goes from the judge to LURC, but we've proven that that's not what the supervisory relationship is still going there, which again proves the whole point, right? That bias comes from who can fire ultimately, because we tend to see this the bias in favor of the state of Wisconsin. Again, the secretary there with these ALJs. But you don't have to take my word for it. Okay. The decision of the administrative law judge is set aside and the matter is remanded to the division for further proceedings consistent with this decision. But everybody signs it, but I believe it's by Maxwell, but we'll find out. Procedural history. On May 2nd, 2022, the complainant, by her attorney, filed a complaint with the Equal Rights Division. All right, so we're only like 3 years later, so that's not the end of the world here. Of the Department of Workforce Development, alleging that the respondent discriminated against her based on her race, sex, and because she opposed discrimination in the workplace, all in violation of Wisconsin Fair Employment Act. On March 10th, 2023, an equal rights officer issued an initial determination finding probable cause to believe that the complainant was discriminated against as alleged. Consequently, the matter was certified to hearing before an administrative law judge. This is the case, by the way, where the complainant has testified that Jeremiah Holiday pointed to his skin and told her that she needed to understand what team she was on, or words to that effect. I may be paraphrasing there. Um, but I believe that's up, so you can see that for yourself. Consequently, the matter was certified to a hearing before an administrative law judge. In a pre-hearing conference report and the scheduling order issued on May 2nd, 2023, the administrative law judge notified parties that the hearing in this matter was scheduled for November 7th through 10th, 2023, and that all pre-hearing discovery must be completed no later than September 8th, 2023, with any pre-hearing motions, including motions to compel discovery, filed by September 15th. The pre-hearing order specified that if motions were filed, briefs in response to these motions would be due within 14 days of the motion, the date the motion was filed. All right, so that's a big indication there that they're putting some weight into pre-hearing motions. On May 17th, the respondent served on the complainant a first set of interrogatories and requests for production of documents. The discovery request consisted of 7 interrogatories and 10 document requests. The complainant was notified that the response would due no later than 30 days from the date of service. On June 16th, the respondent's attorney sent an email to the complainant's attorney agreeing to extend the discovery deadline by a week. On August 1st, 2023, the respondent's attorney sent a letter to the complainant's attorney stating that the discovery responses were 5 weeks overdue from the date of the extension, indicating that he had called the complainant's attorney on 2 occasions and left a message, but was still waiting to learn when the discovery responses would be provided. On August 8th, the complainant's attorney informed the respondent's attorney by email that he had just returned from vacation and would submit his discovery responses by August 11th. Okay. On August 16th, at 2023, at which point no discovery responses have been received, the respondent filed a motion to compel discovery. In that, I don't remember that being the case or not, but that may be the case. In the motion and supporting brief, to produce answers that she extend the discovery deadline in order to give the respondent opportunity to conduct additional discovery based upon the answers supplied by the complainant, and that she award the reasonable fees and costs associated with bringing the motion. On August 18th, the complainant's attorney sent the email to the respondent's attorney that he was surprised by the motion to compel discovery because I've sent you 2 USBs in the mail now. The complainant's attorney indicated that he believes he sent the USB last week and the 1st of July, and he would now arrange for hand delivery of them. On September 1st, 2023, the respondent's attorney sent a letter to the administrative law judge indicating that the complainant had failed to file a reply brief to its motion to compel discovery. We're going to go look at that 1 second. I want to say one thing about that, which is simply this. There was a time, and it seems like that time is over, but we've mostly just moved by that, where if you sent anything, especially to Madison, as a USB drive, it just was not out of Milwaukee. It was not going anywhere. And I don't know if they have a box of my USB drives there or what, but it was a whole thing. I remember that, especially with the because the Department of Corrections wouldn't set up like a link, a shared file. They said it was insecure or something. So we had to pass these USBs, and it was a whole, I remember that. Okay. Footnote 1, although no briefing schedule was issued, the May 2nd, 2023 pre-hearing special that all responsive briefs would be due within 14 days, giving the complainant until August 30th in which to have filed a responsive brief. Okay. And ask you to issue an order granting the motion. Okay. Also on September 1st, 2023, presumably after receiving a copy of the respondent's attorney's letter, the complainant's attorney sent an email to the administrative law judge acknowledging that we owe the respondent discovery and stated that he attempted to send discovery responses by UPS, which did not work. The complainant had stated that his paralegal had been sick all week. Jeez, this guy's got a lot of excuses, but he will, I'm sure, deliver this discovery as soon as he is able. The complainant's attorney also asserted that because the respondent had filed the motion to compel without first conferring with him, the motion was moot. On October 2nd, 2023, the respondent's attorney sent another letter to the administrative law judge indicating that he had attempted to confer with the complainant's attorney, who stated on 2 occasions the complainant would provide written discovery responses. However, the respondent had received no discovery responses nor any response to his motion to compel discovery. The respondent's attorney requested an order that the complainant responded to the discovery request. Okay, send a letter to the parties in their turn, both by regular mail and email, addressing respondent's motion to compel discovery. The letter was misdated December 10th, and a subsequent email from administrative law judge indicates that the correct date was the 10th. Okay. In her letter, the administrative law judge noted that the response had provided the necessary information in support of its motion to compel discovery, including a statement indicating sincere attempts have been made to resolve the matter. However, rather than ruling on the motion to compel, the administrative law judge instead ordered the complainant to respond to the respondent's discovery motion. The complainant was instructed that this response must include an explanation for the complainant's failure to comply with discovery or to attempt to work out the problems which the respondent's attorney, and should demonstrate that the complainant has now complied with the respondent's discovery and for or has resolved any discovery disputes with the respondent's attorney since the filing of the respondent's motion. The complainant was advised that she must submit this response by October 16th of 2023, or the complaint would be dismissed. The complainant was further ordered to take immediate steps to respond to the respondent's discovery request and to resolve any discovery issues with the respondent's attorneys. The administrative law judge order concluded with the following: if the complainant fails to respond to the respondent's discovery request and fails to respond to the respondent's motion by October 16th, 2023, then the complainant's complaint will be dismissed because 1, the complainant failed to comply with the respondent's written discovery request, and 2, because the complainant has failed to comply with my order to respond to the respondent's discovery motion. If the complainant files a response to the respondent's discovery motion, the administrative law judge will consider the complainant's response and make a decision on the respondent's motion regarding attorney's fees and extending all discovery deadline. All right, emphasis and original. Oh, that's interesting. Okay. On October 11th, the complainant's attorney responded that he was happy to comply but needed an additional 2 days. The administrative law judge responded as follows: as for the complainant now has 4:30 p.m. on October to respond to the respondent's discovery motion. However, it is still my expectation that the complainant will take immediate steps to comply with the respondent's. Jeez, okay. At 4:46 on October 23rd, the respondent's attorney received an email from the complainant's attorney containing discovery responses. The discovery responses were not signed and were numbered pages 1 through 40. A minute later, at 4:47, the complainant's attorney faxed discovery responses that were not signed and numbered pages 1 through 44. Both sets of responses included a signed medical records authorization form for an individual other than the complainant. A few minutes later, at 5 p.m., the complainant by her attorney submitted signed discovery responses, this time marked as page 1 through 6. The final submission again contained the incorrect medical reads. Following day, on October 19th, the complainant's attorney sent an email to the administrative law judge indicating that the respondent had received signed responses to all discovery requests and that new medical records recently received by the complainant, and that therefore the complainant had complied with the administrative law judge's order. Okay, on that same day, October 19th, 2023, the respondent's attorney sent a letter to the administrative law judge requesting that she dismiss the complaint. In his letter to the respondent's attorney stated that the complainant had failed to submit a response to the motion to compel that at 4:46 and 4:47 that on October 18th, the respondent received unsigned discovery responses that were incomplete and included medical authorizations for the wrong employee, and that at 5 p.m. it received signed discovery responses, which also included the incorrect medical release. The respondent argued that because the complainant had failed to submit a response to its motion to compel and failed to submit discovery responses prior to the 4:40 deadline, in her complaint should be dismissed. Okay, here's where I am on some of that. I just don't. I have to put it like this: if you are appealing something on a particular issue, okay, and which is everything before, just for example, everything before this point doesn't matter. This is the decision that the judge made that's incorrect. Okay, everything before that doesn't really matter, and everything after that doesn't really matter, even if you kind of disagree with some of these facts in here. Okay, now I don't have any right. I don't know if we've read these, I haven't read these or not. Um, but I'm interested to know. Oh, yeah, now it's come back to me. Okay, got it. Okay. Here's just to clear that up. What I mean is, I think there's just some discrepancy between the facts that they're stating here and my personal recollection. And I don't think that I'm worried about that in terms of, what the actual outcome is one way or the other, or in general in terms of, I mean, these aren't, um, this isn't the best scenario, but assuming that in all of those things that they never got any discovery of any kind, okay, let's assume that that happened. Okay, it still then doesn't, even given all those facts, it still doesn't matter, and at least it's helpful to everybody to understand where exactly the line is. Okay, that's how I can explain that a little bit better. But this is not exactly my recollection, but I don't know that it behooves anybody one way or the other to say to go look and find out where it was or wasn't wrong at this point, because it's not really in contention. Dude, I hope that's more clear. The respondent argued that because the complainant the responses to its motion failed to submit discovery responses prior to 4:30 deadline, her complaint should be dismissed. On October 24th, the law judge sent a letter to the parties describing several ways in which she believed the complainant's response was deficient and indicating that the complaint would be dismissed. Specifically, the administrative law judge know that the complaint had responded after 4:30, failed to submit a response to respondent's motion to compel, failed to explain the complainant's failure to comply with the respondent's discovery request, failed to explain the complainant's failure to attempt to work out any discovery problems, failed to submit any responses to indicate that the complainant had now fully complied with the respondent's request for discovery. Later that day, the administrative law judge issued an order of dismissal. In her order, the administrative law judge indicated that the complainant had willfully filed failed to timely comply with the respondent's reasonable discovery request and the administrative law judge's discovery order regarding the respondent's attempts to obtain discovery responses from the complainant and the resulting discovery motion by the respondent. On or about October 25th, 2023, the complainant filed a motion for reconsideration. On October 30th, the administrative law judge issued a letter denying the motion for reconsideration, indicating that the motion would be treated as a petition for petition for commission review. The division memorandum opinion that the administrative law judge has the same authority to compel discovery and to issue protective orders and to impose sanctions as a court under 804 Stats C Wisconsin Admin Code DWD 218.14.4. That's what it says. Here we go. Ooh, this is pretty nice. Let's get to the statutes. A motion for order compelling discovery. A party upon reasonable notice the other parties and all persons affected thereby may apply for an order compelling discovery as follows. Motion. If a party fails to answer an interrogatory or an order compelling, okay, if they do that. Failure to comply with an order. If a party fails to obey an order to provide or permit discovery, the court in which the action is pending may make such orders in regard to the failure as are just and among other things the following. And then it says, or dismissing the action or proceeding or any part thereof. Okay. Now, that's going to be, again, we got the facts here. Now, this is what the standard is. Okay. That's what we're talking about. And then they're going to apply a little bit more rule here to flush this out. The standard to apply when reviewing an administrative law orders imposing a sanction for noncompliance with the discovery order is whether the commission finds that the administrative law judge's decision to have been an abuse of discretion. Under the standard, the question before the commission is whether the administrative law judge examined the relevant facts, applied a proper standard of law, and used a demonstrated rational process reached at a conclusion that a reasonable judge should reach. In this case, the complainant's attorney repeatedly failed to cooperate in this discovery process or to provide timely discovery responses upon request, nor has the complainant's attorney provided any reasonable explanation for these failures. However, notwithstanding the complainant's attorney's conduct, the commission nonetheless concludes that the administrative law judge's dismissal of the complainant's case as a sanction for failing to comply with discovery was not a reasonable exercise of her discretion. I'm gonna pause there. I'm not surprised that it's going to be put out like that. As noted above in the procedural history section of this decision, the administrative law judge received a motion to compel from the respondent but failed to rule on the motion in spite of the fact that respondent's attorneys had provided the necessary information in support of the motion, including statement indicating that sincere attempts have been made to resolve the matter. Okay? And so I guess maybe you can see there that it may have been the case that we didn't address in our motion or procedural history any issue. We put it another way. Our analysis very likely started on them applying for this motion. Very likely. Okay. The administrative law judge issued an order requiring the complainant to file a response to the motion to compel and instructing her to take immediate steps to respond to the discovery request, two directives that were inconsistent. If the administrative law judge was considering the merits of the motion as a requirement that the complainant file a response to the motion suggests was the case, then simultaneously ordering the complaint to take steps to respond to the discovery request was premature. If, on the other hand, the administrative law judge intended to grant the motion and require the complainant to comply with the discovery, as the portion of that order stating that she must take steps to do so suggests, then the complainant's explanation for failing to provide discovery responses earlier was no longer relevant. All right, we're just going to pause for 1 second right there. I mean, I think we should just play the recording. And yeah, sorry for the jump, and I'm not re-angling it, but here we go.
Right.
That's the first one right there. Yeah, that's what ALJ Coffins and they're talking about that one in the junction right now. All right. Thank you. All right. I guess we got that one. In addition to the fact that requiring the complainant to both respond to the motion and submit discovery requests was inconsistent, the commission is not persuaded that it was appropriate to require the complainant to file a response to the respondent's motion to compel discovery. Although the May 2nd, 2023 scheduling order issued by the administrative law judge contemplated that each party would receive 14 days in which to file responsive briefs if a motion was filed, The filing of responsive briefs by the complainant was not a requirement or mandate. Rather, submitting a brief to the administrative law judge would have been an opportunity for the complainant to be heard on the issue. The complainant's failure to submit a responsive brief simply meant that the administrative law judge received no explanation for the complainant's action and could rule on the motion to compel without the benefit of hearing the complainant's side of the story. Once the respondent submitted its motion to compel, complete with sufficient information to allow the administrative law judge to rule on the motion, and the complainant was given the opportunity to respond to that motion, the administrative law judge should have been able to issue an order specifically addressing the motion to compel and resolving the discovery dispute. A brief from the complainant was not a necessary prerequisite for the administrative law judge to do so. Even assuming, however, that the administrative law judge could properly require the complainant to submit a brief in response to the discovery motion, the statute that permits dismissal of a complaint as sanction for failing to comply with the discovery order does not permit dismissal of a complainant as sanction for failing to do so. Administrative law judges have only such authority as given to them by statute. The authority to dismiss a complaint as a sanction for failing to comply with discovery is contained in 804.12, cited in more detail above, which provides that the dismissal may be appropriate if a party fails to obey an order to provide or permit discovery. The administrative law judge's order requiring that the complainant respond to the motion to compel was not an order to provide or permit discovery, and the commission is unpersuaded that the administrative law judge had the authority to dismiss the complaint as a sanction for the failure to supply such response. It must also be noted that the complainant did provide discovery responses on October 18th, on which the date on which the administrative law judge directed her to respond to the motion to compel, as indicated above. While the complainant did not comply with the directive to respond to the motions to compel, once she supplied her discovery responses, such a response was essentially moot. Having provided the requested discovery materials, any explanation as to why the complainant had not responded sooner or what steps she undertook to resolve discovery issues was of no consequence. Here's, I think, what I can add on that. These are like major arrows of the ALJs just being yanked right out of their quiver. That's probably better. How to yank? I mean, depends how, if you're modern, whatever. But yes, um, major quivers being the foundations ultimately of strategies are being withdrawn, like so many I don't know, so much sand possibly. Geez, that's terrible. I got myself in a rhetorical trap there. Should have worked on that ahead of time. Yeah, I'm impressed that this what another thing that I can say is you can see here how we just got through some pages of, let's say, Ben is an incompetent oath because, okay? Now, it's not my place to say what really, it's in no interest of my clients to say anything about that and leave it be mum here. But the last two paragraphs really represent, I just want you to understand, probably hundreds of hours of consternation that I've had to deal with administrative law judges on this issue. In fact, I'm being threatened with it right this very moment. This very moment. So that's very critical that we're clear on what we're doing here. Very critical on what we're doing here. In fact, very critical. Very critical. Oh man. Oh, I literally, I can tell you about 30 hours of consternation recently. I think that maybe at least 15. How about at least 15? And yeah, remember, there's one thing that is when I am in consternation, for example, uh, it's difficult to do other things that I probably should be doing. And for example, that's time that's being taken away from Honey, Smokes, and all the rest. And Smokes needs her time. Let's be honest. Um, let's be honest. So there are causes and effects to everything here. You know, the administrative law judges Larissa Benitez Morgan's decision, which is eventually is being argued for. She's getting essentially free lawyers. Angela Ford is not. Um, so there's cost to everything here. This hearing was 13 days. I think that should have been first top of the thing in there. That's so far my main thing that I would add to the facts is, but 13 days from the hearing, she does that because that was just gross. Um, it's also extremely important to understand that the another more important thing was that the commission had ruled some months before that had been personally hand delivered to Larissa Benitez Morgan. I don't know if they're going to talk about this or not. That's told them that if they wanted to dismiss a case, they had to have a hearing with the complainant. And no such thing happened. And that I filed this motion. I mean, it may be in there because I put filed this motion for reconsideration, but I think that's extremely important. I didn't see that fact anywhere in there, but that's extremely important. Nor is the commission persuaded that the fact that the complainant's discovery materials were submitted after 4:30 justified a dismissal of the complaint. The administrative law judge's order was that a complainant must file a response to the motion to compel discovery no later than 4:30 on October 18th, and that she must additionally take steps to respond to discovery. On another point, the administrative law judge's October 11th email to the complainant's discovery specified, as for your request of 2 days to respond to the order, it is hereby granted the complainant to respond to the 4:30 on October 18th, 2023 to respond to the respondent's discovery motion. However, it's still my expectation the complainant will take immediate steps to comply with the respondent's discovery motion. Neither the October 11th, 2023 email nor the administrative law judge's original order required that the complainant to submit her discovery responses at any specific date or time. Okay, I'm going to pause this right here and just to say a little bit of attorneys are people too moment. Um, I probably haven't filed anything close to 4:30 because she freaks me out to such a degree, and the amount of stress that I had to dealing with Stolar because of this 4:30, this non-time limit turning into a time limit thing, retroactive time limit really caused physical discomfort to me. Um, I guess we could call that traumatic. So to the extent that, let's put it like this, that I had that opportunity to empathize with my clients when they describe emotional distress arising from adverse employment actions, I appreciate that opportunity. Rather, the complainant's attorney was instructed to take immediate steps to respond to the discovery request. The order contained no explanation as to what was meant by steps, but the fact that the complainant's attorney submitted her discovery responses between 4:46 and 5 o'clock p.m. Sorry, there's a footnote that says, although the respondent's attorney has indicated the discovery responses supplied by the complainant's attorney on the complainant's behalf were incomplete, the respondent has not explained how the respondent's responses are deficient. The only matter the respondent's attorney pointed out was that the complainant's attorney submitted a medical release pertaining to the wrong individual. However, while it does appear that the complainant's attorney sent the wrong medical release, it does not appear that the respondent's discovery request contained a specific request for a medical release. Oof. Yeah, I got that there. All right. Neither Okay, October 18th, 2000, the date which the complainants on which the complainant's response to discovery motion was due would appear to put her in compliance with the administrative law judge's directive. Further, while as indicated above, the administrative law judge's order did not require a discovery response by any date or time certain, even if it had, it would be difficult to justify dismissal of the complaint where the requested discovery materials were received within a half hour of the deadline. That's so important. That's so important. Thank you, LIRC. Thank you, LIRC. Thank you, LIRC. Um, there's a lot of pro se people out there, others out there that might benefit by that ruling in the future. I think that's very important. And so far, by the way, this is all arguments going to Ben. I mean, to the complaint. Um, that's the only thing that we get credit for, by the way, is an argument. All right. That's huge. 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 That's called dicta right there. That is what you call dicta. Huge. All right. I'm going to ask you here. Do you, based on this here, just the tone into now, I want to say, because as I indicated before, they're going to talk about, um, they're going to talk, the final paragraph is going to be another one to me, but they don't mention that the administrative law judge knew about it and told her about it beforehand and like knew all about it and LURC gave it to him and it was on purpose. They don't say that there. But we are saying that here because we have that public records request. Thank you very much. And we did present it to them. I don't, they have their own reasons for leaving that out there, but whether or not that influenced their decision, it's hard to know because it's not in here. But it's significant. It's significant. And again, what that's saying here is you administrative law judges don't go dismissing complaints just because someone hands in discovery. A half an hour can mean, I mean, that's okay. Finally, it should be noted that the commission has held that while when the you know what I'm going to do? I'm not going to translate that for you. I'll leave that up to you to translate. When the party failing to make discovery is represented by legal counsel, the administrative law judge must determine whether the party is blameless in the discovery failure when considering an appropriate sanction under the chapter. And it is abuse of discretion to order dismissal of a complaint without having made a determination that that party, as opposed to the attorney, was at least partially to blame. Due process. How many? That's one. That's two. That's three. Vanderbush. That's four. That's four rulings. Now we got five. Five rulings. I was never a good compound count. In which the court restricted judicial discretion to dismiss a matter by holding that the order ring dismissal with prejudice based on the conduct of a party's attorney would be an abuse of discretion by a judge if the attorney's client was blameless for the discovery failing. Thus, even if the commission were to conclude that the complainant's attorney violated an order of the administrative law judge requiring the complainant to provide discovery, dismissal of the complaint as a sanction would be inappropriate absent a conclusion that the complainant shared some of the blame. I hope you'll take my word for it that that's pretty darn stern. One might feel rebuked. One might. For all of the reasons set forth above, the Commission finds that dismissal of the complaint as a sanction for failure to comply with the discovery was not a reasonable application of discretion on the part of the Administrative Law Judge, Larita Benitez Morgan. The Administrative Law Judge's discretion is therefore set aside, and the matter is remanded to the Administrative Law Judge for the completion of pre-hearing discovery, and presuming that the complainant will fully and expeditiously cooperate in the discovery process, for a hearing on the merits of the case. Oh, so they leave open discovery. All right. I I think everybody might enjoy having a little bit of discovery at this point. Um, benefit, I think, is probably the better word. Enjoy the benefit of a little discovery at this point because um, let's see if there's anything more. No. So let's see what's there. Well, after a year and a half, what day was this? October 11th of what year? 2023. Okay, after 15 months, the administrative law judge's decision is therefore set aside and the matter is remanded to the administrative law judge for the completion of a pre-hearing discovery, and presuming that the complaint will fully and expeditiously cooperate in the discovery process for hearing on the merits of the case. Now, this is going to be difficult. This is going to be difficult because one can assume that there may be, this is an NPS case, and there may be some Calvin Furman issues there. So it may have to go out altogether. But we can be sure that the case is likely not going to be based on the recent events. This case will not be heard by Larissa Benitez Morgan going forward. Again, she is hearing cases. I'm still examining hearings, from what I understand, but I don't believe she's examining mine. So I I don't know. I mean, how can I best put it like this? I have no information to prove one way or the other that the commission knows about the hot mic recording. Um, no, I think we can conclude that they do know about it. I think we can conclude that it's been sent to them. If let's just go, we're going to assume that they're neutral, but let's just imagine a world in which they do know about it, okay? And that meaning, sorry, scratch that. Let's imagine a world in which the person who wrote this direction, that it go back to the administrative law judge, set aside to completion of pre-hearing discovery. Okay, let's assume that a world in which the person who wrote that knows that that person is not going to actually do that. Okay, my best guess what their motivation would be is to not screw over the complainant, meaning fix things for the complainant because that complainant deserved to hear. But there is some very important battles here that I have been fighting for some time, and that they have just boom, boom, boom. I mean, it's absolutely the case. Also, the information that I'm saying, they could have decided this issue on many grounds. And what meaning the first one, we're gonna one, two, let's, I think there's one, two, three decisions that they make, and then say also, it's also noted, by the way, you're supposed to talk to the complainant. Okay. They could have picked one, or two or three, any one of those decisions, and said, that's enough. We're not going to talk about anything else. They could have chosen the last thing and said, that's enough. We're not going to talk about anything else. So they could have also put in there the judge the jerk because in there too. I mean, I think that there was a realm of enough information out there for them to have wrote up that kind of essay. Okay. So I think I hope you can understand both from their point of view, the people writing this. I'm guessing, um, and that is, I hope you don't take this all too personally, Lurk. I don't. Part of what we're doing here is, there's a critical critique of criticism, and this is jurisprudence. That's the big distinction here between and why we're examining this as like this. It's just jurisprudence. I think I'm on the clear on. I can say that when I'm trying to be as distinct before, I'm trying to say something that is different than I think this is the right decision because obviously I feel that way. How could I've given my bias? How could I say something else? And I'm not just trying to get around that. I think I'm trying to say that there's a reason. I understand the reason. I think that it's applied in a clear way. Jurisprudence. Okay. So I'm just final, I think, comments here about all this is that I do think that they took the time, that this is a message to ALJs. I do. And hopefully they will heed much of this, um, because I think it's I mean, not only is it's the law, what it's supposed to do is guide their conduct, um, but I think it's easy to understand. So, thank goodness to Angela Ford for hanging in there throughout this. Um, she needs to have her hearing, but she's also proven some very important things. Very important things. And, the way that the Anglo-Saxon model of law works is that the person who proves these things really gets to, I mean, it's going to be in the digest. Her name will be cited for quite some time. I'm going to be cited great, but she gets the privilege of paying. So, bittersweet at best. But it's a good day. Thanks for sticking with us. We'll keep you informed. Right? Let's hope so. I will say, I mean, it may very well be her statements of the Supreme Court. She's always been proven right, and her statutory interpretation is so good by Judge Benitez Morgan that caused this. Again, we don't have enough information. We're just reading tea leaves and speculating here. Um, but wouldn't that be ironical?